Hello and welcome back to the GDPR and Data Protection Diaries. In this video we're going to be looking at the role of the DPO, so the role of the Data Protection Officer under the GDPR, but more specifically when there is perceived to be a conflict of interest between the individual carrying out that role and whether they're carrying out the role, a different role within the organisation. So doing the DPO role and another role and whether that creates a conflict of interest. The reason we're going to do this is because there has been a judgment issued by the Belgian Data Protection Authority, I think it was on the 28th of April, that has fined an organisation €50,000 for having a conflict of interest between the role of the DPO and another role they were carrying out within the business. There are a couple of other things in there that we need to talk about, but we'll go through that as we go through the video. As always, if you find this content useful, please do give us a like, give us a thumbs up, give us a share, and comment down below and let me know your thoughts. Who does the role in your business? Do you feel there's a conflict of interest? And how do you create that level of independence, really? What do you do about it? So what's the case? Well, the case is that the Belgian Data Protection Authority have fined an organisation called Proximus €50,000. Now, the fine relates to more than one thing. It relates to a conflict of interest in the role of the DPO, which is what we're going to be talking about today. It also relates to a lack of accountability from the DPO, so the individual that was doing the role. And it also relates to not listening to the DPA and not having any interaction with the Data Protection Authority when a breach occurred, which is why they started to investigate and what brought all of this stuff to fruition. So the first thing that we want to look at is the role that was being undertaken. So obviously the individual was acting as the Data Protection Officer. So to be the Data Protection Officer within an organisation, you have to be able to act independently. So you have to be able to act without instruction and also without having any influence over the processing activities or the business activities of the organisation that you're working for. So you are there to protect the rights and freedoms of the individuals and obviously to make sure that the organisation is being compliant. The challenge that a lot of companies have with this is obviously, where do you find that person? Having a dedicated data protection officer is an expensive activity. There's a resourcing cost associated with that. There's obviously salary, there's benefits, there's pensions, and also finding somebody with the right level of experience and that suits your organisation can be a tricky process. So what many organisations have done is give the role of DPO, where they need to somebody already within the organisation. Now, in this particular case, the role was appointed to the Director of Risk, Audit and Assurance. Now, on the face of it, that actually sounds like quite a good place for the role to sit. In my view, risk, audit, assurance tends to be advisory. You are overlooking the business, you're giving comfort and support to the business and its activities, and you're generally not being involved in any day-to-day processing decisions or activities. The issue that's arisen in this case, there are actually two parts. So the first part is that while acting as the Director of Risk, Assurance and Audit and acting in the role as the DPO, there are some good risk management frameworks in place. There's a good risk assessments are being done, but the individual in their role as DPO is only seeing the outcome of those risk assessments. So under the regulation, under Article 38, the DPO is required to be involved and consulted in risk assessments and activities related to assessing the risks of processing. Being given the outcome of an audit or the outcome of a risk assessment is not necessarily classed as being consulted. You should be informed, you should be in the meetings, and you should be attending and actually helping the organisation and advising them on the risks as they go along. The second part of this particular finding actually relates to where they decided, or where it was determined, that there was a conflict of interest between taking on the role of Director of Audit and Assurance and Risk and then being the DPO. Now, this is actually where it gets quite interesting, because what the courts have found and what the Belgian Data Protection Authority have found is that by conducting the role of risk and audit, particularly audit and overseeing the audit function, the individual is likely to have access to confidential information, particularly about employees and about the role that the employee has taken within the business, and potentially the activities that that employee has done that may have brought the business into disrepute, or may mean that the employee is acting outside of their employment contract. Now, as a DPA, you have a duty of confidentiality, so you are there to protect the confidentiality of the individuals whose information you protect. That is at odds with carrying out an audit function where you are investigating potentially those same individuals in the case of the employee. You may need to provide their details within an audit report, so you may need to report on findings, and potentially those findings could also relate to disciplinary actions or could lead to disciplinary action if the audit was looking at internal fraud from somebody within finance, for instance. And that's where the conflict of interest in this case has come about. So the role of the DPO, acting as an independent, acting and controlling the confidentiality of the individuals who are coming to them for support, is particularly at odds with carrying out that audit role. This is not saying that nobody, no head of, no director of can also be a DPO within an organisation. That is not the case, but there has to be that balance of duties. And that's something that the organisations have always probably been aware of, but haven't really looked at. This is not the first time this has been the case. In Germany, there was an incident or a case where there was an IT director who was also appointed as the DPO. And of course, because they have control over the security functions of the business, they couldn't give that independent view that the DPO needs to give. So again, that was seen as a conflict of interest. As a rule of thumb, within your organisation, if you are looking to have internal resource acting as your DPO, you should avoid anything where the individual may have control or decision-making ability over how the business is run. So avoid anybody in marketing, any head of marketing, accounts, finance, customer services, operations, and of course the CEO, the MD, and any board level director is unlikely to be able to have the required level of independence to carry out the DPO role and carry out their role on top of it. There are obviously solutions. You can appoint an independent DPO, so have a specific individual within your organisation whose role is to just act as your DPO. You can also look to use somebody like the company secretary, who is actually a very independent individual, or you could look to have a third party such as the chair of an audit and risk committee, or somebody with an outside view. That also includes the use of an external third party to provide an outsourced data protection officer service, which you can then call upon, and it acts completely independently from within the business, meaning that they are not being told what to do, how to act, and they have no vested interest in allowing the business to carry on an activity that may actually be in breach of the regulation. So the key takeaway here is that not all internal roles are going to cause a conflict of interest, but there are going to be some instances where that needs to be looked at. Obviously, this is run through the Belgian courts. This hasn't run through the UK courts, but in terms of EU law, it certainly sets a precedent, and it is something that we're going to have to keep an eye on moving forwards. And obviously, as we hear and learn more about it, we will come back and let you know. I will put the findings from this particular case down in the comments below. Field Fisher have done a fantastic summary of it, and I'll dig that out and pop that down in the comments below as well. I'd be really interested to know your thoughts, how you feel about conflict of interest in the role of the DPO, and how you deal with that in your organisation. And as always, if you have any questions, please do get in touch. Aside from that, please do give us a like, comment, share, and subscribe to the channel if you find this video useful. And we very much look forward to talking to you again soon. Thanks very much.